ಹಲೋ ಅಣ್ಣ ಒಂದ್ಸತಿ ನೋಡಿ ಅಣ್ಣ.
ಹಲೋ
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸ್ಪೀಕರ್ ಹೆಡ್ಫೋನ್ ಅದೇ ಅಲ್ಲಿ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹಲೋ
ಇಲ್ಲಿ ನೋಡ ಇದಾಗ್ತಾ ಇದೆ, ಗ್ರೀನ್ ಆಗ್ತಾ ಇದೆ.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್? ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಮೇಡಮ್ ನಾನು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್? ಮೇಡಮ್ ನಾನು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಾನು ಮಾತಾಡೋದು? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಸರ್ ನಾನು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಮೇಡಮ್ ನಾನು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್?
ಕೇಳಿಸುತ್ತೆ ಸರ್, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಹೌದಾ, ಸರಿ ಮೇಡಮ್. ಅದಕ್ಕೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಯಾಕಂದ್ರೆ
ಇಲ್ಲ,
ಕೇಳಿಲ್ಲ
ನಾನು
ಅಂತ
ನಿಮ್
ಮತ್ತೆ
ತರಾನೇ
confusion ಆಗುತ್ತೆ.
ಪಾರ್ಟಿಸಿಪೆಂಟ್, ಬಟ್ ಅವ್ರು ಯಾರು ಇದ್ದಂಗಿಲ್ಲ ಹೈಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಹೌದಾ
ಅವರು. ನಾನು
ಸರಿ ಸರಿ.
No, sir. Tomorrow I'm not sitting, I told you. Yes. Told. 2:31 matter ಇದೆ, officers are here. ಅದು ತಗೊಳ್ಳಿ, ಆಮೇಲೆ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್
ಅದೇ ಕೊಡಿ. ಏನ್ರಿ ಇದು? ನಮ್ ಕೇಸಲ್ಲ.
He was here. ಬೇರೆ ಕೋರ್ಟ್ ಇದ್ದಾರೆ.
ಪಕ್ಕದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಗೈಡ್ಲೈನ್ಸ್ ಗೆ ಅಂತ ಹೋದ್ರು ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಅವ್ರ ಕೋರ್ಟ್ಗೆ.
ಎಸ್ ಎಸ್
ಶೋರ್ ವಿಲ್ ಕಮ್.
ನೀವು ಹೇಳಿ,
Milords,
ನಿಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡಿ.
the contents of
ಸಾರಿ, ಇದೇನೋ 4 PM ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಸಾರಿ.
So I'll
We'll take it at
wait.
4 PM only. Yes. Then 2:30 ತಗೊಳ್ಳಿ.
Matter pertains to principal bench. Bill number 1, Nataraj D.
My lordship.
Jagdish sir.
The concurrent my lordship.
Nataraj ಅವರೇ, ಇದು impossible to pass, most dangerous order. Different transactions ಎಲ್ಲ.
ಇಲ್ಲ my lordship. No, there is supportive judgments I have produced my lordship.
Different
Yes.
transactions ಇಲ್ಲ, supporting judgments. That's the whole problem. Anyway, you keep it ready. I'll post it on 3rd in Bangalore itself.
Yes my lordship.
List on 3rd.
Bill number 2, Sumana Naganan.
For the respondent.
2 and 3 also on 3rd. Abhinav Baji. Just want that. Anyway, ಹೇಳಿದ್ರಿ, that's gone to the carpet. Yes.
Very well, very well.
Yes, next.
Bill number 3,
3 no, they same.
Bill number 4, Anita Abraham.
No, I'm appearing for the petitioners in this matter.
Anything survives in this now?
My lords, in fact, it's a little bit, I have just gotten in touch with the petitioners. It
Yes.
turns out, in fact, that they have just had a child.
All right, yes.
So, but however, I'm still seeking instructions from them because petitioner number 1, the husband is traveling.
No, then I'll post it on 3rd, madam.
Please, yes, by then I
Yes.
get instructions, yes.
List on 3rd, yes.
I'm grateful.
5, Ireshar Budihar.
Not in this matter, not the ED had not said no objections for not following the petition. This is a prayer not sought for by the competent authority.
No, true, but is it going to affect the depositors some in any kind?
It may not, because not competent authority is the one, not who will have to not distribute not the proceeds, not to the authorities. Otherwise,
Alright,
it becomes free,
Ah.
not, then we may not be in a position to not give back to the depositors.
Then we'll dispose this on those terms.
Yes. Your Lordship may record that not ED has no objection for all.
Yes, the learned counsel appearing for the respondent P. Prasanna Kumar, Enforcement Directorate, submits that the Enforcement Directorate has no objection to allow the petition. Allow the petition would mean grant the prayers that are sought. In that light, disposed. Yes.
Please.
Next.
Bill number 6, Gaurav N.
My lords, appearing for the petitioner, my lords. My lords, on this occasion, I reserve this matter for judgment, my lords.
I know. It's pretty madam.
My lords, this stands covered by my lord's judgment in Paritosh, my lords.
Third.
Section 7,
Yes, list on 3rd.
fresh matters list, my lords.
3rd ಅಲ್ಲೇ ಇರ್ತೀನಿ, ಎಲ್ಲ matter ಅದೇ.
Much obliged, lords.
7, Dalwai Venkatesh, Prasanna Kumar.
Petition is, not I had submitted not third status report, not which contained not few not prayers not on behalf of not CBI.
Those directions will have to be given.
Please,
Looking at the report, I will dictate them on Thursday.
please.
Yes.
Please.
Yes. Next, ಅಷ್ಟೇ. Principal, ನಮ್ಮ bench go. Prabhuling sir is there?
Yes, madam. Yes, madam.
The other further hearing matter, ಅದು by mistake disposed ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ರು ಮೊನ್ನೆ.
Oh. No, it is
ಅದಕ್ಕೆ-
lordships actually disposed it on saying
No,
lordships.
So
Sorry.
I had reserved it, and then you made a mention that you wanted to make some more submissions. So I posted it for further hearing.
ಅಲ್ಲ ಅವತ್ತಿನ ದಿನ 174(5) lordships heard me and Mr. Jagadish. ಅವತ್ತು 174(5) ಕೆಳಗಡೆ lords, he had not heard the police officer ಅಂತ on that ground lordships said short ground.
Oh, on that ground is it? All right.
Not
Yes.
for merits, not on merits.
Disposed, yes.
Please.
All right, disposed. Oh, that Supreme Court judgment, latest judgment, yes.
Pardiwala just lordships.
Yes, all right.
Yes.
My lords, serial number 6, my lords. In fact, my lords had disposed it off on the last occasion, my lords.
3rd will do it, sir. Yes.
Yes, my lords.
Yes.
My matter, my lords, Bangalore,
Which one?
where senior counsel is appearing, lords, Mr. Jagdish is also
ಅಲ್ಲ,
appearing.
ನೀವು ಒಂದು ಯಾವ್ದೋ ಒಂದು ಬಿಲ್ಡರ್ದು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಲ್ಲ.
Same.
ಪ್ರಭು
Same.
ಸರ್ ಅಂಡ್ ಇದೇ
Please.
ಮ್ಯಾಟರ್ ಅದು.
ಅದೇ matter.
ಅಲ್ಲ, ಅದೇನಾ ಇದು?
ಹೌದು
ಹೌದು,
ಸರ್.
ಹೌದು.
406, 420.
Correct, not the same one.
What other submissions you wanted to make in this?
No, ನನ್ನ ಕಡೆಯಿಂದ ಏನಿಲ್ಲ.
Then I did not hear Monish that day at all then.
No, my lords, please, my lords, I was,
No, you are not there. But 175 follow ಮಾಡಬೇಕು ಅಂತ it is to be sent back ಅಂದ್ರು ಅದಕ್ಕೆ. I had reserved this matter actually.
please, my lord.
That's what I was searching.
But what actually happened was we had argued, and at that point of time, Mr. Jagdish pointed out this question. Mr. Jagdish
true.
pointed out to
But
Supreme
pointed
Court
out the
judgment.
question, but
Then I
I did not
agreed.
hear. I did not hear Monish on that.
No problem, no problem.
Then I'll post it on 7th, 6th.
Please.
At Bengaluru bench, please, my lords.
Of course, yes, sir.
So very grateful.
The subject petition was heard and reserved for its orders on 20th January 2025. The learned senior counsel Prabhuling Navatgi had had made a mention subsequently that he had some more points to submit, and therefore the matter was listed for further hearing. On 20th February 2025, the matter is erroneously shown as to be disposed, as the counsel Monish was not heard in the matter. Therefore, list this matter on 6th for further hearing at 4 p.m. We will hear him and then pass out.
Please.
Yes.
Grateful, please, my lords.
Yes. Last. Dharwad best. Huh? 230 ಇದೆ ಬೇರೆ ಯಾವ ಮಾಡು 160 160
230 matter 160. Chetan T. Limbekai, Dinesham Kulkarni.
ನಾವು ಕೇಳಿಲ್ಲ ದೀಪಿಕಾ ಬಂದಿದ್ದು ಅಂತ ಹೇಳಿದ್ರು ಎಲ್ಲ ಹೋಗಿದ್ದಾರೆ. ಕಾಲ್ ನೋವು ಹೋಗಕ್ಕಾಗ್ಲಿಲ್ಲ ನಂಗೆ. ನೀನು ಹೋಗಿ ಸ್ನಾನ ಮಾಡ್ಕೊಂಡು ಬರ್ತಲ್ವಂತೆ ಜೊತೆಲಿ ಕಾಲ್
allegations, demanding that he retract the statement. During this verbal exchange, C.T. Ravi, who was less than 10 meters away from me, made inappropriate and obscene gestures and began shouting at me, repeatedly calling me so and so, which left me utterly shocked. Despite my visible distress, he continued to approach me, making lewd gestures and continuing to call me so and so more than a dozen times. Lord, why I'm reading this is that it constitutes a criminal offense. Offense under 73, 75, and 79, which I don't think they dispute. What is not in dispute, my lord, is that the House was not in session, which is based on my complaint and subsequently 2 complaints by the accused here, petitioner herein, and the others. Lord,
One
Now-
clarification, if I have correctly understood what the petitioner says, whether House is in session or not in session is not his issue. He says the judgment of the apex court in Ajit or any other case deals with acts physically done in the parliament or in the legislature. Here he says it's a spoken word. Now you may speak anything, all that is immune is the submission of Prabhuling now. That's what I'm only telling you whatever is spoken
yes,
is immune.
yes.
We speak about that, we speak about this, is relied on so many judgments. So whatever is spoken is immune. Acts done may not be. Suppose you said somebody is killed.
Speaking is
inside.
also an act.
Allah, that will answer.
Yes.
No, that you say that somebody is killed, somebody is murdered, somebody is assaulted, something is done. All that would come within the ambit of acts done. Now, this is not acts done. It is a spoken word. Whether a spoken word of any kind, that is what he says, of any kind, can become a subject matter of judicial review. Tomorrow, every word, somebody may not like anything. Somebody may not like something spoken by the parliamentarian or the legislator. He will register a complaint saying this, he has defamed me, so defamations will come. He has done that, this will come. Whether that would be, that is the answer I require, that's all.
Basically,
That is all.
privilege.
If I've correctly understood what he says is that a distinction he sought to make while making his submissions, that it is not the acts done that is amenable to judicial review. It is the acts done is amenable to judicial review or whatever, not the spoken. Any speech, any kind of speech.
Well, it's
We
what-
speak about judges in the parliament, we speak about that. We speak about everything. All that if one thing comes out, then if you give this as thing, tomorrow it will be opening Pandora's box. Is what this is submission. If I've correctly
Go
understood.
one step further and say acts of omission and commission would also constitute an offense.
No, acts of omission,
Yes.
they're acts.
Yes, acts.
They're
Acts
acts.
of omission is remaining silent.
Acts of omission.
Are criminal offense.
That
That's what I'm
is-
saying.
You'll have to answer.
Yes.
That's
Yes, acts of omission also, any act which constitutes an offense, the privilege cannot be enjoyed the judgments have said in so many words.
Yes. Now, judgments are all there. ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
That's ultimately what is, in
There
a
is
nutshell,
no,
what
there is
he,
no qualm about the law.
no, what he wants to say is, it's a privilege.
Yes, it's
He
a
claimed
privilege.
it's-
I can speak anything in the
Well,
parliament or
that
the
is dealt
legislature.
with,
It's a privilege.
Let the learned SPP.
194.2 and 194.3.
That is
Article
precisely
194.
what is dealt with in Sita Soren. We will show.
That's all. That's all.
That's
That's
all,
the
madam.
answer I want.
What is a privilege is what is dealt with.
That's all. Yes.
My lord, now they would not dispute that this act of commission was not during the session. My lord, he is admitted, my lord. Or I might have to establish that, my lord.
No session, no session. He says privilege is available. That's the submission of Proceedings. Am I right, sir?
Yes, my lord. Yes, my lord. Correct. Yes.
Unmute.
Their defense is also
Yes,
that
my lord. Yes, that is the submission.
Yes.
there are 2 complaints, my lord. One at Annexure C, Annexure E, subsequent to my complaint. Now, what the speaker holds at the outset that, may I read, my lord? Page 41, Annexure G.
Yes.
Kindly turn to my lord, page 51, my lord.
ಬಂದಿದ್ಯಾ? ಎಸ್ ಸರ್.
ಸದನವು ಮುಂದೂಡಿದಾಗ ಸದನದಲ್ಲಿ ನಡೆದ ಒಂದು ಘಟನೆಯ ಬಗ್ಗೆ ನನಗೆ ಎರಡೂ ಕಡೆಗಳಿಂದ ದೂರು ಬಂದಿದೆ. ಸದನವನ್ನು ಮಧ್ಯಾಹ್ನ 12:52 ಮುಂದೂಡಿದ ತರುವಾಯ ವಿಧಾನ ಪರಿಷತ್ತಿನ ಸಭಾಂಗಣದಲ್ಲಿ ಆಡಳಿತ ಹಾಗೂ ವಿರೋಧ ಪಕ್ಷದ ಸದಸ್ಯರು ಪ್ರತಿಭಟನೆಯನ್ನು ಮುಂದುವರಿಸುತ್ತಿದ್ದರು. ತದನಂತರ, my lord, the others may not be relevant, my lord, for the reason that the house was not in session is what I am trying to establish.
I don't think you should labor on that.
Yes, my lord.
Session, no session, privilege is always available, is what he says.
No.
No, that's a submission. So
One is, it should be, house should be in session and it should be in respect of a business transacted. These are the, my lord, the categorical words used by
Ajit.
Sita Soren's
Sita Soren and Ajit.
and Ajit and all the others refer to therein, my lord. Would any criminal misconduct or criminal conduct would be amenable to? It is a parallel jurisdiction where the courts can interfere, step in, and my lord, now if these facts are there, my lord, for your lordship, that house was not in session and commission of an offence under IPC, my lord, constituting an offence under section 75 and 79 are made out, my lord, they could claim immunity under section 194(2) is the issue before your lordship. Now, my lord, 195(2) has two parts.
Constitution couldn't.
One is publication. We are only concerned with 194(2). Lordship gets it now. Subject to sub-article 1. Subject to the provisions of this constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. No member of the legislature, my lord, there is two things in this, my lord. One is legislature, house in session. House of legislatures is different from legislature. That is defined. Yes. Now, no member of the legislature of a state shall be liable to any proceedings in respect of anything said or any vote given by him in the legislature or any committee thereof. And, my lord, second part we don't deal with. And no person shall be liable in respect of the publication by or under the authority of the house of such legislature of any report from paper, votes, so and so and so. My lord, we are only dealing with the first part. A lot of judgments have been relied upon in Sita Soren's with regard to the second part. We are only, my lord, again I am harping upon, my lord, reiterating that anything said in respect of anything said or vote, my lord, proceedings in any court in respect of anything said or vote, any vote given, which is, my lord, defined in so many words in this judgment. My lord, I'll briefly take your lordship through the judgment to say that I'm sorry. Lord, I'll straight away take your lordship to para 95, Lord,
Of Sita Soren.
of Sita Soren.
All right. Para 95.
95.
All right.
They say houses of parliament and legislature are no islands
Hmm.
which act as an enclave to shield the parliamentarians from the ordinary laws.
Para 90.
Para 95, Lord, it should be at page 700.
Seven.
95, Lord. There are two tests, Lord, laid down there.
The necessity test.
Yes. The necessity test for ascertaining parliamentary privilege has struck deep roots in the Indian context. We do not need to explore the well-established jurisprudence on the necessity test in other jurisdictions beyond and above the exposition of Indian jurisprudence on the subject at this juncture. The evolution of parliamentary privileges in various parliamentary jurisdictions has shown a consistent pattern that when an issue involving privileges arises, the test applied is whether the privilege claimed is essential and necessary to the orderly functioning of the House of its committee or its committee. Lord, only this and nothing else, Lord. They've said in so many words here afterwards. We may also note that the burden of satisfying that a privilege exists and that it is necessary for the House to collectively discharge its functions lies with the person or body claiming the privilege. The House of Parliament or legislatures and the committees are not islands which act as enclaves, shielding those inside from the application of ordinary laws. The lawmakers are subject to the same law that the lawmaking body enacts for the people it governs and claims to represent. Lord, they have said it in so many words, Lord. We therefore hold that the assertion of a privilege by an individual member of parliament or legislature would be governed by a twofold test. First, privilege claimed has to be tethered to the collective functioning of the House. And the second, its necessity
That's
must
what
bear a
ultimately
functional relationship.
Nexus test
Yes, Lord.
should have the nexus to what?
Discharge of
Nexus to the business of the
yes,
House.
transactional business. This they have said in so many words.
Lawmakers are subject to the same law and lawmaking
yes.
body enacts for the people it governs
Yes.
and claims to represent.
Kindly go to 104, my lord.
So the king can do no wrong, agalla.
104, my lord.
Yes.
The principle which emerges from the above cases is that the privilege of the House, its members and committees is neither contingent merely on location, nor they are merely contingent on the act in question. A speech made in Parliament or legislature cannot be subjected to any proceedings before any court. However, the acts such as damaging property or criminal acts may be subjected to prosecution despite being within the precincts of the House. Clause 2 of Article 105 grants immunity in respect of anything said or any vote given. The extent of this immunity must be tested on the anvil for the test laid on above. The ability of a member to speak is essentially tethered to the collective functioning of the House and is necessary for the functioning of the House. A vote which is an extension of the speech may itself neither be questioned nor proceeded against a court of law. The phrase in respect of is significant to delineate the ambit of immunity granted under sub-article 2 of Article 105. Lord, they would refer to Kyoto's case, my lord, where they say floor crossing does not enjoy immunity. Kyoto Holyoke, my lord.
Yes.
Then, para 114, my lord, the courts and House exercise parallel jurisdiction is what they say. Lord, and then what is legislature and House of Legislature is defined, my lord, to say that House of Legislature is not when the governor summons the House exercising powers under 168. Legislature, my lord, would include within its ambit the legislature, the committees, and the head of committees. House and legislature mean not House in session. Lord, this act was committed neither in the legislature, nor in the committee, nor in the head of committee. Lord, that
After the proceedings were over.
after the proceedings were over, Lord, even the live video coverage was, Lord, the moment the speaker wakes up, Lord, gets up, raises, it is switched off. So we had to, Lord, borrow the footage from the private operators who operate inside the House. Then, Lord. Lord, the facts, Lord, would your lordship like to know the facts?
Facts,
coming-
but
facts.
I wanted to the law.
Yes,
No,
Other-
wanted an answer on law.
yes, yes.
So Sita Soren is,
Sita Soren, right?
Ajit is clear of acts done.
Yes.
It's all right.
Yes. My lord, whatever constitutes a criminal act either acts of omission or commission, my lord, is a criminal offense. Here, my lord, the FIR would disclose a criminal offense. So
No,
therefore,
it is 354A. The crime FIR would disclose that it is an offense of outraging the modesty of a woman.
509
That's
also,
what-
my lord, I will,
Fine.
my lord.
509, not 354A.
Yes, 509.
509.
My lord,
No, there, 509, condition number 2 is a spoken word also.
illa.
No, really.
A spoken word also. That's why
That's what I'm saying.
509 was introduced because spoken word was there. Lord, that's why I would rely on Lord. One more judgment. The constitutional offense, not like that. My judgment.
Now,
in
here-
Abhijit's case, Lord, I just
No, here you mean to say that when C.T. Ravi spoke, the house was not, everything, proceedings were over.
it is an admitted fact, my lord, because they have relied on the speaker's verdict. They cannot approbate and reprobate. Now in the statement of objections, they say, we wouldn't want to rely on that. They cannot do that.
No, that is because for a reason he was telling.
For a
That they would
reason,
not want to rely. It cannot be relied in a court of
Cannot
law
be-
is what
cannot
he
be
said.
subject
That is
matter
why
of-
he is saying he is not relying.
it cannot be a
There's
subject
no-
matter of review by the High Court.
He's not
Yes,
approbating.
yes.
By mistake, it is produced and ಹೇಳಿದ್ದು.
Yes. So therefore, there is no
Yes.
counter to the fact.
And he has not relied on that also.
He's made it part of and
Out
category.
of the record, but he said I'm
He's
not.
relied in para 15, para 18, para 41, para 42. He's relied.
ಅದು ತಪ್ಪಾಗಿದೆ ಗೊತ್ತಾಗದೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
To the extent to show that house was not in session, my lord, I would use that. It is not a subject matter of any test before the court. No, my lord. This is not before your lordship to say that even the spoken word constitutes an offense. Abhijit, my lord, was the state of Kerala, para 22, section 351 IPC prescribes the punishment for outraging the modesty of a woman by an act of assault or use of criminal force. In spite of the existence of the aforesaid provision in the Indian Penal Code, the legislature has incorporated section 509 in it, making punishable even a verbal attack of insulting the modesty of a woman.
Correct.
So
That's what I
therefore,
told.
it constitutes an
That
offense.
is the condition. There.
Yes. So the intention of the legislature is evident. Commission of acts which may not necessarily involve even any physical advances or assault is also made punishable under section 509 IPC. Originally, the punishment prescribed for the offense under section 509 was simple imprisonment for a term which may extend to 1 year or fine. The punishment provided for the offense now stands enhanced to simple imprisonment for a term which may extend to 3 years. So therefore, that argument would not stand, my lord. So I will place this judgment before your lordship. I have nothing more to say, my lord. That's it.
Yes, sir.
That's a lot of mistakes have happened in
Well,
this.
One more judgment.
Sorry.
I'm sorry. This judgment, my lord, the term filthy language when examined in isolation and without any contextual framework or accompanying words indicating an intent to insult the complainant does not fall within the purview of 509. Had there been references to specific words used, contextual details or any gestures, Lord, here my complaint is lewd gestures were there. So the court says,
Yes.
therefore I'm not 28, para 28, Lord. Para 28. The complaint clearly says, immediately the complaint was lodged, there was no afterthought. Post my complaint, madam, these two complaint surfaces. And the speaker holds that unpleasant things have happened, it should not have happened. And they'll have to introspect, is what they say. Yes.
Yes.
Okay, let's.
Yes, sir.
Yes.
ಈಗ ನೀವು ಇನ್ನೊಂದು ಓದಲ್ಲ ಅಭಿಜಿತ್ ಯಾವ್ದು ಅಭಿಷೇಕ್ ವಿಚ್ ಎವರ್ ಯು ರೆಡ್ ನಾವು ಕೊಡಿ ನೀವು ಓದ್ಬಿಟ್ಟು ನೀವೇ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರ ಎಸ್ ಪರವಾಗಿಲ್ಲ ಮೇಕ್ಸ್ ಆರ್ ಜಾಬ್ ಈಸಿಯರ್ ಅದೆಲ್ಲ ಗಾನರ್ ದೋಸ್ ಡೇಸ್ ವೇರ್ ಇಲ್ಲ ಗಾನರ್ ದೋಸ್ ಯು ಆರ್ ಮಾರ್ಕಿಂಗ್ ಅಂಡ್ ಗಿವಿಂಗ್ ಯು ಆರ್ ಟ್ರೈಂಗ್ ಟು ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ನಥಿಂಗ್ ಡೂಯಿಂಗ್ ಅವೆಲ್ಲ ನಮಗೆ ಇಟ್ ಮೇಕ್ಸ್ ಆರ್ ಜಾಬ್ ಈಸಿಯರ್ ಕೊಡಿ ಅವೆಲ್ಲ
Get offended. Lot of things have changed, my lord.
Yes.
Lot of things.
We are the new age judiciary.
New age.
Yes.
It seems like we were in Stone Age.
Yes.
Too many mistakes here, my lords. As your lordships observed, they made a mistake in producing the proceedings of the house.
That is the first mistake.
First mistake, calling me something.
That is of course. That is the root cause.
Mother of thing.
Root cause.
Root cause. Please see the third mistake, what they do in the cost title also.
ಅದ್ರಲ್ಲೂ ತಪ್ಪ
ಅದ್ರಲ್ಲೂ ತಪ್ಪು.
ಏನಂತೆ?
Please, at least in our petitions, ನನ್ ಗಂಡನ ಹೆಸರು ತಪ್ಪು ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ, ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ನಮಗ್ ಕೊಡೋದ್ರಲ್ಲೆಲ್ಲ
ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
Anyway, my lords, that was on a lighter vein.
Yes.
Now, my lords, so far as privileges are concerned, lords, the entire issue is covered with great respect in Sita Soren's case, my lords. If your lordship kindly take, my lords, that now it is a settled position that when somebody claims privilege, judicial review is available. Your lordships can decide whether it amounts to a privilege. My lords, I would only say history of privileges is traced from 49 to 64, my lords. But please come to para 62 in that judgment, which your lordship should get at running page, my lords, subject to correction. It is 60, my lords. Para 62. In fact, my lords, we are dealing with a situation where privileges were claimed even prior to we getting independence.
The colonial reluctance. Yes.
My lords, I would only say this. Probably, my lords, in India, for the first time, privileges came through Lord Macaulay, my lords. That's also traced.
Correct.
Even he, in his wildest dreams, never thought that such a thing would happen in the house. My lords, at para 62, if your lordship sees, at no point, your lordship gets it, my lords.
Yes.
At no point where these privileges demanded as a blanket immunity from criminal law. Even in the face of colonial reluctance, the demand for parliamentary privileges in India was always tied to the relationship which it bore to the functions which the Indian legislature sought to discharge. This background prevailed when the Constituent Assembly was. Then it goes on, my lords, I'm only showing, my lords, where, please see in 63, the last 4 sentences, that bears the.
Yes.
The Constitution was therefore born in an environment of idealism and a strength of purpose born of the struggle for independence. The framers intended to have a constitution which would light the way for a modern India. Then, my lords, it goes how privileges and what were the debate on privileges. Then, my lords, if your lordship come to para 68, Article 105 is discussed, my lords, from 66 onwards. I'm just taking because of time limitations, my lords.
Yes.
At para 68, 105 having 2 limbs is discussed.
Yes.
Then, my lords, in that, what is important in 68 and in 70, my lords, their lordships, my lords, discussed Tej Kiran Jain's case in 68, which your lordships, I'm sure, would have dealt with it, my lords. Then, my lords, please see 70, para 70, my lords, where they discuss about Kalpana Mehta's case. Now, what is spirit? Because the entire thing today is they're claiming privilege based on speech, whether it amounts to speech. Now, my lords, what it means is set out in Kalpana Mehta. In 70, my lords, if your lordship sees in Kalpana Mehta, it starts just below. Your lordship gets it, my lords.
Yes.
In Kalpana Mehta, one of us had occasion to elucidate the importance of this privilege. Parliament represents collectively through the representative character of its members, the voice and aspirations of the people. Free speech within Parliament is crucial for democratic governance. It is through the fearless expression of their views that parliamentarians pursue their commitment to those who elect them. The power of speech exacts democratic accountability from elected. The free flow of dialogue ensures that in framing legislation and overseeing government policies, Parliament reflects the diverse views of the electorate which an elected institution represents. Then, my lord, the Constitution recognizes free speech as a fundamental right in Article 19(1)(a). A separate articulation of that right in Article 105(1) shows how important the debates and expression of view in Parliament have been viewed by the draftspersons. My lords, if your lordship then goes through entire, my lords, the judgments and discussions, the crux of the issue is if privilege is claimed, whether it is speech, action, anything, my lords, it should be towards, my lords, what they are elected for and what purpose they were.
That's what nexus to the business of the house.
Business of the house or anything. Now, my lords, if it is a speech, that's why I'm saying, my lords, it depends on fact to fact case. If it is a speech, then your lordships will have to now decide, because the lordships have the jurisdiction to see whether the words used, the actions that are performed.
For example, a legislator slaps B
Yes.
becomes an offense.
It-
A legislator abuses filthy language or whatever is
Yes.
used, does not become an offense.
It-
No, that is what is the.
That's what they are
correct-
trying to know. My lords,
Yes.
this, that's why I'm saying if your lordship sees the history, how they have come about, my lords, no one in their wildest dreams would have thought that a day will come and we'll see all these things. This is how, my lord, that's why they say constitution is an organism.
No, it's
We
a,
are now growing, we are seeing things which are happening.
no, that's dynamic. It can't stay
That is
static.
how, my lords, that's how they have dealt with it. That's why, my lords, I can take your lordship to the other things. Please come to para 74 for a moment, my lords. That's at page 64.
No, I have already marked it.
Your lordships have marked. That's where they say it
I've
should
just
be
now
within
read
the
it, yes.
confined. Then, my lords, I'll only,
Unlike in the House of Commons.
Yes.
We are different is what.
now, my lords, para 76 deals with reference 1 of 1964.
Yes.
There, my lords, please come to the next page at page 65, towards the end of that and before the quoting of it, my lords. There, your lordship should get just before quoting of the para 37. The court held at page 65, about 5 lines from top. The court held that the parliament or the legislature, that's in para 76, I am reading.
Come to para 79.
79, yes, my lords. In fact, the lordships again hold at 77
No,
interplay.
79. We've explored the trajectory of parliamentary
Yes.
privileges, especially the freedom of speech in the Indian legislatures.
Yes.
It has been a timeless instance. Legislators' freedom of speech carry out their essential legislative functions,
That
be protected and sanctified.
then, my lords, para 80 also, your lordship. may
80
kindly
also,
say.
yes.
In a consistent line of precedent, this court has held, firstly, parliament or state legislature is not the sole judge of what privileges it enjoys. And secondly, parliament or legislature may only claim privileges which are essential and necessary for the functioning of the house.
Right.
Now, is these words used? Would it, my lords, in any manner, my lords? Then, my lords, I will also
No,
take
that I told, but now the development of law had stopped with the P.V. Narasimha Rao's case.
Yes,
Now Ajit gives in a little more.
my lords.
Para 101, Ajit is referred to.
Yes, yes. My lords, before that, can I trouble your lordships to come to para 82 also, my lords? I'm sorry, I will be.
No problem. Yes, sir.
It starts with the privilege exercised by members individually is in turn qualified by its necessity, in that the privilege must be such that without which they could not discharge their functions. We shall elucidate this limb later in the course of judgment. These privileges enjoyed by members of the House individually are a means to ensure and facilitate the effective discharge of the collective functions of the House. The privilege of an individual member only extends in so far as it aids the House to function, and without which the House may not be able to carry out its functions collectively. None of which, my lords, with great respect, I would say would go on in this. My lords, and 87 is what is first 3 lines, my lords,
Yes.
of 87. Para 87 at page 68. Only 3 lines, my lords. The privileges enshrined under Article 105 and Article 194 of the Constitution are of the widest amplitude, but to the extent that they serve the aims for which they have been granted. Then, my lords, I will only take 92. Your lordships may kindly see. The evolution of parliamentary privileges as well as jurisprudence of this court established that members of House are indeed, the House itself cannot claim privileges which are not essentially related to their functioning. To give any privilege unconnected to the functioning of parliament or legislature by necessity is to create a class of citizens which enjoys unchecked exemption from ordinary application of the law. This was neither the intention of the Constitution nor the goal of vesting parliament and legislature with powers, privileges, and immunities. Para 92.
Yes.
So that goes on. Then para, of course, your lordships saw the other paras. My learned friend read 95, but I would see 92 read up to 96, my lords, actually sets out what it is.
Yes. Normally it goes on the facts of the case.
Depends on the
After
fact.
that,
Yes, after that,
it goes
my
on
lord,
the primary issue.
here, yes, that issue we are not concerned for. But what I'm trying to make out is, now, my lord, 7 judges have categorically held that privileges, of course, judicial review is available.
That is there, that is now by now.
Secondly, it should be essentially, my lords, towards the some function for which you are elected. Now, calling me names, abusing me, is that the purpose for which you are elected? Now, whether it is right or wrong, it's a subject matter of investigation. But today, if you are going to claim privilege, whether the house is in session or not, I will not even get into that aspect. But my lords, whether
Your synopsis or.
just a
of
short
judgments-
synopsis of
Short
this,
synopsis of judgments or any arguments also.
because all this is covered out. The earlier judgments I didn't even bother, my lord, because
Because this covers.
this
everything.
covers the entire all the judgments.
Yes. So you can say.
The conclusion drawn by the court should be looked into.
194.
194(4), 194(6),
Yes.
Para 194.
194.
and whether the
So
act,
that was read by the senior counsel himself.
whether the act constitutes an offence. These are the two tests, not your lordship required.
Yes, Prabhuling sir, anything?
Let's. I am very conscious of the fact that it is almost 5:30 and lordships have heard us sufficiently. But my lords, having regard to the seminal importance of the matter, wherein lordships are going to decide an important issue, it would be my duty, my lords, to assist your lordships with vote for 5 minutes. With reference to Sita Soren itself.
Yes.
Before that, my lords, permit me to make this statement before your lordships with reference to Article 212. Lordships may kindly examine Article 212
Yes.
of my, please. Article 212.
Yes.
Please. 212 subclause 1 would say the validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity or procedure. Subclause 2.
Yes.
No officer, or
And then,
member
yes.
of the legislator of state in whom powers are vested by or under this constitution for regulating procedure or the conduct of, or for maintaining order in the legislature shall be subject to the jurisdiction of any court in respect of the exercise by him of these powers. So the reason why I have read before your lordships is, Lord, in A.K. Subbaya's case, lordships may permit me to demonstrate it in this manner. In A.K. Subbaya's case, petition was filed before this honorable court, alleging that certain statements were made by the members in the house which constituted contempt of court and other related offences under the Indian Penal Code. Action was not, mandamus was sought to register criminal cases against them. Lordship may permit me to test this. This honorable court rejected the writ petition relying upon 212s to state, whatever has been said inside the house, we cannot go into it. Lordship may not kindly. This is exactly the fact situation even in Tej Kiran's case, wherein some members had met. Now, what emerges from those two decisions is, what happens in the house? The court cannot direct the police to register the cases. Well, let us say in this case, for some reason, if the CID would have refused to take up the complaint of the respondent number 2 in respect of something said to me, said by me. If respondent number 2 is to approach your lordships for a mandamus, your lordships, if you are to follow A.K. Subbaya's principle and the other Tej Kiran principle, would have to reject the writ petition saying that I cannot direct registration of the case because that has happened in the house. It is only a reverse situation where they have gone and registered, where in the other two cases they are not registered. This is one aspect of the matter. Now, lordships may kindly see Sita Soren.
Yes. Lordships
are, and one day sentence held. But Sita Soren, lordships are aware, we are considering reconsideration of P.V. Narasimha Rao's case. In
Yes.
P.V. Narasimha Rao's case, Lord, in P.V. Narasimha Rao's case at paragraph 13.3, in Sita Soren, para 13.3. Lordships first see para 13, Lords.
Yes.
Paragraph 13, Lord. Their lordships quote the minority opinion of His Lordship Justice S.C. Agarwal. But kindly, on the other hand, S.C. Agarwal held that neither the alleged bribe takers nor the alleged bribe givers enjoyed the protection of Article 105(2), that is vote given. An MP does not enjoy immunity under Article 105(2) from being prosecuted for an involving the offer or acceptance of a bribe for speaking or giving his vote in Parliament or any committee. In his opinion, Agarwal held as follows. Kindly skip that, not kindly 13.3. This is Justice Agarwal's opinion. The phrase in respect of must be interpreted to mean arising out of immunity under Article 105(2) is available only to give protection against liability for an act that follows or succeed as a consequences of making the speech or giving of vote by an MP, and not for an act that precedes the speech or vote and gives rise to liability which arises independent of the speech or vote. This is His Lordship Justice Agarwal's view, my lords, which said where money was taken by the legislatures prior to voting. Lordships may kindly see. Therefore, His Lordship Justice Agarwal says what precedes the act is not protected. That was a minority view. That Lordship's para 14 makes it clear. G.N. Ray in a separate opinion showing so last sentence in para 14, the opinion authored by S.I. Agarwal, on the other hand, represents the view of the minority. Now, this view, Sita Soren has two parts. This view is overturned and P.V. Narasimha Rao is reconsidered, where their lordships hold that what has been preceded, that the act of taking money by the legislature under reference, lordships may permit me to say, cannot be the subject matter of a protection under 105(2). So this is all Sita Soren says. Thereafter, however, their lordships did examine the real scope and ambit of 105(2). Sorry, not 194(2). On the first day, my lord, I made this submission before your lordships. 194, my lords, has 4 sub-articles. 194(1), very interestingly, my lords, gives us a right to speech in the legislature only subject to the regulations to be made by the legislature. But whereas lordships have seen Article 19 also gives a fundamental right to citizens of freedom of speech, that is subject to executive restrictions. The constitutional makers thought it fit that we should not restrict the right to freedom of a speech of a legislature under Article 19, though they made it specifically under 194 subclause 1. 194(2), my lord, amplifies this and says, whatever you have spoken under 194(1), you will not be subjected to the ordinary courts. 194(3) is interesting, my lord. It speaks of privileges and immunities. Something different from 194(2).
Yes.
Yes. There, my lord, they did not define what is privileges or immunities. They said, in other, it starts by the word, my lord, lordships have said, in other respects. That is not besides speech and vote.
Yes.
The powers, privileges, and immunities of a house of the legislature of the state and of the members of the committee of a house of such list shall be such as may from time to time defined by the legislature by law, and until so defined shall be that of the House of Commons. Therefore, my lords, the privileges were not defined. They were left to be defined by the House itself. This is very interesting, but because all the paragraphs my learned friends have read out is in the context of 194 subclause 3. Why the two tests are laid down by His Lordship Justice Chandrachud, my lords, is in this context. In the absence of there being a definition of a privileges, if the legislature propounds a particular privilege, how do we accept that privilege to be a privilege under 194(3)? Therefore, their lordship then say, we will apply these two tests. That privilege should be necessity. That privilege should be for functional relationship of the legislature. That test obviously, my lord, without a doubt cannot be made applicable to 194.2, and their lordships have not said so, and I will show it before your lordships. Because 194.2, my lords, need not be interpreted at all. All that it's 194.1 and 194.2, it simply says, I have a right of speech. And if that speech, for whatever I have spoken, that's what Tej Karan sings, whatever I have spoken.
According to you, it's an unbridled right of speech.
Under
in the
194.2.
Parliament. 194.2, correct.
Yeah. Unbridled right to speak. And whatever I am subjected to the legislature. 194.3, however, my lord, 194.3, however, is first day I said, my lord, it is dynamic. 194.2 is static. The question of functional, my lord, it will be rewriting 194.2. If the argument of my learned friends are accepted, then we have to read 194.
So, according to you, what all is relied on is relatable to 194.3.
I'm sorry.
No. I'm sorry. Whatever they have argued, your submission is that they're all relatable to 194.3, and 194.2 gives you absolute power of speech of any kind inside the parliament or the legislature.
Yes, and lordships are aware we are interpreting the constitution, not any statute. I'm just only.
No, I am aware we are interpreting the fountainhead of the statutes.
I'm not saying
the
this
statute.
Lordship Justice Rohington Nariman, in one of the speeches I recollected, he quoted an American judge. I was trying to. He said, "Don't forget we are interpreting the constitution." In that context, I said, "Let's ordinary 190."
I have not forgotten at all. Yes.
No. For a moment, I'm not. I'm only trying to. When I say these things, for whatever I have heard sometimes, which has inspired me, I'm only bringing to lordship's notice. The reason is the reason is this. 194.2 ಅಲ್ಲಿ ambiguity ಇಲ್ಲ ಅಂತ my respectful submission to you.
That you have submitted.
Yes. This twin test concept and all, why it became necessity, my lords, is, in fact, Sita Soren did not call for that discussion, but their lordships have discussed it academically and otherwise. The reason they felt 194.2, 194.3, we have to put some shackles on them by applying these two tests. Where is the question of lords telling today, no, this speech of Mr. Siddharth inside of the house is whether relevant or not. Who is to decide that? But they will say it is not relevant. I will say it is relevant. But kindly visualize this situation. When somebody gave this an example. Let us say, the Honorable Chief Minister is addressing the house. Let us say on a particular debate. And the matter is going on. One member gets up and says that you have stated wrongly, or this is not part of it. He is not called. There is no order of the business. Someone can say, no, you were nowhere called to speak. The persons who were, for example, in Parliament, lordships are aware, persons are listed. List kodtare. Suddenly somebody gets up. Then they say it is not in order. This becomes nebulous situation. And we enter into an area or terrain, lords, which is prohibited under 212 is my respectful submission. As soon as you start applying these tests as to whether it was relevant or not relevant, whether it has functional relationship or not, we enter into an area which is prohibited is my respectful submission to
No. We will not write anything that would would become nebulous.
My understanding,
be specific in whatever I write. Yes.
It is in response to their argument.
Correct.
The argument is you put this functional test whether it is essential member. Now, for instance, what I will say, protest in a well of the house is very essential for a legislature. It is
that is true. Sir, that has clear nexus with your functioning.
Correct. That's all.
The issue is commission of a crime which has no nexus with the functioning. That's the issue.
But may I make
alleged crime?
But may I just qualify that by making this statement? If the allegation is that crime has occurred on account of a speech made by me, the test will not apply is my respectful submission.
All right.
But Sita Soren, I'll connect those lordships held up. I'm very conscious. I'll be failing in my.
No problem. Yes. You can also file your written arguments. No problem.
File additionally also I'll file.
Yes.
Paragraphs, I'll just leave it to you, lordships. SC Agarwal I have shown, lords. 138 ನೋಡಿ ಸರ್. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ನಿಮಿಷ.
ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿಲ್ಲ.
Now the written note ಅಂತ ಕೊಟ್ಟಿತ್ತು. Look, may I request lordships to now kindly see
The written note.
paragraph lords 96. This is
Of-
what Mr. Belliyappa
Sita
has
Soren.
No, in 96, Mr. Belliyappa has read out. Right?
ಅದೇ ಸೀತಾ ಸೊರೆ.
ಹೌದು, ಸೀತಾ ಸೊರೆನ್ ಅಲ್ಲಿ. Paragraph 99, lords. In fact, lords, the Honorable Justice Chandrachud reiterates the principle of Tej Kiran Jain.
Yes.
Then, lords, kindly see para 104, which is very important.
No, that is on the facts of that case, bribery.
104 ದಯವಿಟ್ಟು.
Yes. Yes.
The principle which emerges from the above cases is that the privilege of the house, its members and the committees is neither contingent merely on location, nor are there merely contingents on the act in question. Full point, a speech made in parliament or legislature cannot be subjected to any proceedings before any court. However, lords, other acts such as damaging property or criminal acts may be subjected to prosecution despite being within the precincts of the house. Clause 2 of Article 195 grants immunity in respect of anything said or vote given. The extent of this immunity must be tested on the anvil of the test laid down above. The ability of a member to speak is essentially tethered. Lordships may kindly see. The ability of a member to speak is essentially tethered to the collective functioning of the house and is necessary for the functioning of the house. A vote which is
No qualm about the principle at all.
No, this is not that. Other no, I mean, lordships may then lords kindly see paragraph 100. I'll just give the paragraph. No, lordships may kindly note and at leisure can see 107. Plot 107. Lord, they have said about anything said or any vote given.
One of them to come.
Then lords 108. 108, lords, is the words anything and any, which read with their respective operative words, mean that a member may claim immunity to say as they feel and vote in a direction which they desire on any matter before the house. These are absolutely outside the scope of interference by the courts. The wide meaning of anything and any read with companion words connotes actions of speech, so and so, so on.
Then that is interpreting Narasimha Rao's.
Oh, correct.
What is observed in Narasimha Rao is what is said. ಅದಕ್ಕೆ straight away 194 ಗೆ ಬಂದ್ಬಿಡಿ conclusions.
Is 194.194.
Yes.
Yes, ma'am. 194 point stereo, this is not relevant. 194.5 and 194.6.
Correct.
The expressions anything and any must be read in the context of accompanying expression in Article 105.2 and 194.2. The words in respect of means arising out of or bearing a close relation to and cannot be interpreted to mean anything which may have even a remote connection with the speech or vote.
On the issue 194.8, corruption and bribery of members erode probity in public. See, that is on corruption. That's all right.
Correct.
No, andre, it is not that the court absolves. We will have to answer this, yes.
No, I'll just 1 minute. Therefore, that Justice Narasimha Rao's case, what happened was they had taken some money, etc. That allegation, Prevention of Corruption Act, prosecution was going on. The contention was, see, this is relating to a vote given by me, therefore I am immune. Then that principle is upheld. Justice Agarwal, however, dissented. Minority opinion was...
That's all right, sir. Everything is already here. Why should we go back to the minority opinion there?
No, minority opinion is now, lords...
Correct. Minority opinion is what is elaborated now. That is why everything is here. Why should we go back to S.C. Agarwal's...
Therefore, that 194.6, what? No, the reason is... I'm sorry, one more sentence. 194.6 means not which is preceding and the yak heltarandre avaru. That is money taken prior to voting. No, that is totally irrelevant insofar as ours is nothing. It is not either preceding or I have made a speech even according to them which is derogatory in nature. It is not proceeding. It is arising out of that speech only. This offense is arising out of the speech, therefore fully covered.
Yes, sir.
That is one para 138 is also, Mr. Suman says, regardless of the injury. 138, no, Lordship's mechanism. Cockburn. Cockburn opined that speeches made in either house could not give rise to civil or criminal proceedings, regardless of the injury caused to the interest of a third person. Concurring with opinion of Lush, J held that Parte Vasan said, I am clearly of the opinion that we ought not to allow it to be doubted for a moment that the motives or intents of the members of either house cannot be inquired into by criminal proceedings with respect to anything that they may either do or say to the house. Either.
Against
Yes.
And my lords, one other aspect I must bring to Lordship's notice. They were relying upon that ruling of the Honorable Chairman of the Legislative Council.
Yes.
It is not appropriate, reprobate, or anything. The fact that the Chairman of the Legislative Council has taken cognizance of these proceedings, but completely shuts out their argument that it is not part of the legislature. If it is outside the legislative session, etc., where is the
Why would he take it?
There the question of he taking does not arise.
Last
Orissa, I'll complete. Orissa judgment, Lords, is also we have relied upon in that compilation. Lords, Surendra Mohanty versus Navakrishna Chaudhary. This is the fifth in that compilation, which is the relevant point.
Sir, 89, you can go to page 158.
138.
158. Page 89. Para 89, 93. You can conclude it.
150.
158, paragraph 89.
Lords, paragraph, page 158 of that compilation, para 89. Para 89, there can be no doubt that this was directly a matter of internal management of the House. The Assembly had a right to decide it, and the Speaker has permitted Sri Chaudhary to speak. Sri Chaudhary is hereby protected by the decision of the Speaker. It is said that Sri Chaudhary had exceeded his limits and made breach of privilege. It is not a matter in which the court can examine or investigate. Correct.
Yes.
93.
93 also.
Exclusive.
Exclusive jurisdiction lies with the state legislature.
No, you file your synopsis, sir, complete.
We'll file with all this.
Written arguments, whatever, paragraphs of paragraphs.
Yes.
Last
ಮತ್ತೆ reply.
ಇಲ್ಲ, reply ಏನಿಲ್ಲ. I would only say last mistake. Them relying on Sita Soren. That's all I learned.
Lord, judges were summoned in Keshav Singh's case. Your Lordship has seen that judgment.
Yes.
There, he said there are no procedures. It is 194(3). Subarticle 194(3) is discussed in Keshav Singh. 96 before judgment. So therefore, procedure adopted. And
you don't have to worry. Every submission will be considered.
Yes. Not there. The judges were summoned because the court stayed the proceedings before the Speaker.
Yes.
Lord, I have already said, but I have already made this submission before your Lordship, Lord, that the statement which is attributed to me, of course, Lord, it is denied. But I am very sure no such this kind of statement could have never been made.
I know. You have also said that
we place on record, Lord, without prejudice.
Have the greatest respect for women.
For any woman, Lord, nobody can say that, but nobody has said that. Lord, I am very confident that he has never said it. But anyway, Lord, these are matters, Lord, which the Honorable Chairman has taken note of.
All right. Yes.
Please, I am grateful, Lord.
Heard reserved. You file your written submissions, new synopsis, whatever, but it should be fast.
Yes.
In the next 1 week's time.
Yes.
By next Friday, I would need that.
Very well.
Yes.
Yes.
Yes, Siddharth. By next Friday. Yes. Idena.
Document.
ಯಾವ document?
Siddharth ಅವರೇ ಕೊಟ್ಟಿರೋದು submission.
ಈ ಕೇಸ್ ದೇನಾ? All right. ಇದರಲ್ಲಿ ಇಡಿ. Yes, go to Dharwad. 2:30 movement ಮಿಕ್ಕಿದ್ದು ಕೊಡಿ. ಬೆಂಗಳೂರು ಬಂತ? ಯಾವ್ದು ಕೊಡಿ? ವಿಪಿನ್ ಸರ್. ಏನಿದು?
My lord, in respect of accused number 2, my lord, your lordships have already, my lord, suspended the sentence. In
page?
In criminal appeal number 429 of 25, my lord.
Same order.
Criminal appeal 429 of 25.
429 of 20.
I'm sorry, my lord. Criminal appeal 409 of 25.
409 of 25, same order, the order ತೆಗೆದ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಹಾಕಿ, same order. Yes,
Both the matter.
both
both-
1 and 2, yes. Right, now come to
Right.
Dharwad bench, yes.
My lord, pass over matter.
ಎಲ್ಲ ತಗೊಂತೀನಿ sir, wait, yes. We will not go unless I